Hi, I'm Brad Morgan, and my presentation is over religion and public schools, which is chapter 5 of our textbook, How Do Schools Balance Freedom of Religious Expression and the Separation of Church and State? Today we'll discuss the intersection of religion and public schools, which has sparked legal debates and shaped educational policies for decades. On one hand, the First Amendment protects students' freedom of religion, allowing them to express their faith. On the other hand, the separation of church and state ensures that public schools remain neutral in religious matters. Throughout this presentation, we'll explore legal principles, landmark cases, and best practices to understand what is and isn't allowed in public schools regarding religion. I appreciate how our textbook presents the issues from both sides. In this presentation, I'll do my best to argue the case from both sides. However, I find that one position has a stronger case than the other. Position 1, protecting freedom of religion. Those in this camp argue that the First Amendment guarantees the right to practice religion freely in public schools. They believe students and staff have the right to pray, express religious beliefs, and form religious groups as long as it does not disrupt the educational environment. Freedom of religion advocates battle policies that discriminate against the expression of religious beliefs. Position 2, maintaining the separation of church and state. Those in the Position 2 camp argue that the Establishment Clause prohibits government support of religion in public schools. Prayer and religious customs at public schools or public school events violate the separation of church and state. The Anti-Establishment Clause of the First Amendment prohibits policies and government funding of organizations or events associated with religion. The interpretation of the First Amendment has proven to be subject to one's personal beliefs and experiences and has resulted in complex controversy. So now let's take a look at the First Amendment. The First Amendment reads, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise of, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. The Supreme Court acknowledged that the religion clauses are not precise by design. The Court has said that rigidity could well defeat the basic purposes of these provisions, which is to ensure that no religion be sponsored or favored, none commanded, and none inhibited. Over time, the religious objectives of the First Amendment have become known as the Establishment Clause and the Free Exercise Clause. The Establishment Clause is derived from the text, Congress shall make no law respecting an establishment of religion. The Free Exercise Clause is derived from the text, Congress shall make no law prohibiting the free exercise thereof. So now that we've read the source information of the Constitution, let's look at a few scenarios and put ourselves in the place of the courts and determine the correct legal decision. On this slide, I have listed common scenarios that students, teachers, and community members face regarding the expression of their religion in public schools, or their right to religious omission in public schools. I want you to think about whether each statement is true or false based on your understanding of the law or your experiences of how policy has been enforced. We'll read through the questions now and give the answers on the next slide. True or false? Prayer is not allowed in public schools. Does your school allow prayer at football games, banquets, graduation? Does your school allow staff to lead prayers, or students, or guest chaplains? Next question. Public school teachers cannot talk about their Christian faith with students. Can teachers share their faith and beliefs with students in class? What about outside of class? Can teachers offer their religious beliefs or interpretations of class topics or current events? What about if a student directly asks a teacher, administrator, or coach about their faith? Does that change what is allowed? Question 3, true or false? Bible stories can be read in class. In younger grades, can Bible stories be read to practice reading? Can they be read to teach morals? In older grades, can the Bible be read as a work of literature, comparable to Homer's Iliad? True or false? The phrase separation of church and state is in the Constitution. This phrase has become the most well-known principle in regard to the relationship between government and religion. Where is it written? And the answer to nearly all of the questions is, it depends. Courts have approached these cases in different ways throughout the years. Oftentimes, the context and intent of the actions play a prominent role in how the courts apply the law to these situations. Justices have been known to change their stance in time. The personal beliefs of the court members also play a role in their rulings. Question 4 is a clear false. The phrase separation of church and state is not written in any law. Rather, it was written by Thomas Jefferson in a letter to the Danbury Baptist Association in 1802. In this letter, Jefferson's intent is quite clear and opposite of how the phrase is primarily understood today. Jefferson and the other founders were advocates of men and women of faith living out their faith without interference, restriction, or hindrance from the government. When used today, the phrase separation of church and state is often used as an attempt to make publicly funded institutions a religious vacuum. This was not the intention of Jefferson or the writers of the Constitution. The intent was for religious neutrality. A vacuum and neutrality are much different policies. We will discuss the legal framework that courts have used to navigate the unique situations embedded in this historical debate. Early interpretations of the Establishment Clause and Free Exercise Clause. In Everson v. Board of Education, 1947, the Supreme Court addressed whether taxpayer funds could be used to reimburse parents for busing their children to religious schools. The court ruled in favor of the policy, with Justice Hugo Black arguing that providing transportation assistance was a neutral public service, comparable to police or fire protection, and did not violate the Establishment Clause. He emphasized that the state must remain neutral toward both religious and non-religious individuals. However, Justice Wiley Rutledge and Robert Jackson dissented, arguing that any state funding benefited religious schools indirectly supports religion. Jackson asserted that aiding parochial schools was equivalent to aiding the church itself. In 1962, in the Engel v. Vitale case, the District Board of Education in New York directed schools to begin each day with a state-composed, non-denominational prayer. However, a group of parents objected, arguing that the mandated prayer violated their religious beliefs and practices. The defense argued that the prayer was voluntary and students could choose not to participate. Countering, the petitioners argued that the students were a captive audience and implementing the prayer was coercive. Prayers in this setting pressure or embarrass students who adhere to different religious practices or have no religion. Ultimately, the court ruled that the prayer was unconstitutional. This set a precedence for all group prayer in public schools or public school events. In the following decades, a trend of disallowing prayer in classrooms, graduation ceremonies, and football games emerged. Even if students led the prayers, the belief that attendees would be subject to religious coercion against their will led courts and school officials to ban prayer. In Lemon v. Kurtzman, 1971, the Supreme Court established the Lemon Test, a three-part standard for determining whether government actions violate the Establishment Clause of the First Amendment. The case arose from Pennsylvania and Rhode Island laws that provide financial support to teachers and materials for secular subjects in religious schools. The three parts of the Lemon Test are: the law's primary purpose must be secular or non-religious, the law cannot promote or inhibit religion, the law cannot create excessive entanglement between the government and religion. The majority took the traditional purpose and effect the court had been using since Everson v. Board of Education and added the excessive government entanglement prong to the test. The Lemon Test was used for almost 40 years. The narrow parameters of the Lemon Test has resulted in almost no religious practices in public schools being deemed constitutional by courts. For nearly 4 decades, courts have seemed to neglect that reference to God has been supported by government daily in public government functions and public schools. We only have to look at a coin, such as a penny, to see that the Constitution's true intent is to preserve the freedom of exercise of religion and avoid a state-sponsored church, as was the case with the Church of England when the Pilgrims crossed the Atlantic. Even today, there are countless practices of the institutions and officials of our government, including Senate and House of Representatives sessions opening with prayer. Our most recent presidential inauguration gives an excellent example of the government's proper stance in regards to the role of religion in government functions. 3 pastors stood before the American people and offered religious wisdom, exhortation, prayer, and request for God's blessings. Even within public schools, students are asked each day to join in reciting the Pledge of Allegiance to the flag, in which they proclaim us to be one nation under God. These examples set up the inevitable redirection of the legal path forged by the Lemon Test since the 1970s. In recent years, the courts have abandoned the Lemon Test. The Kennedy versus Bremerton School District case created a major shift in jurisprudence. In this case, public high school coach Kennedy was fired for kneeling for prayer on the football field after a game. Coach Kennedy sued on the basis that the school district violated First Amendment protection of free speech and free exercise. This case restored or emphasized 2 important fundamentals. First, the court held up Coach Kennedy's actions, explaining that the government cannot suppress personal religious expression. The district itself admitted that they targeted Coach Kennedy's actions because of their religious nature, while being permissive of secular actions. This targeting is a violation of the First Amendment's Freedom of Expression Clause and the 14th Amendment's Equal Protection Clause. Second, Establishment Clause challenges have been routinely evaluated in reference to historical understandings. The over-application of the Lemon Test in educational settings has overshadowed the validity of historical practices. The use or preservation of religious symbols have been established time and time again by the courts. Specific examples of religious symbols and customs permitted by the courts include a Latin cross erected as a World War I memorial, municipal nativity scenes, and prayer at legislative sessions. I would like to introduce to you a few current legal cases involving religion in public schools as an opportunity to apply what we've covered in this presentation. In 2023, the Oklahoma Statewide Virtual Charter School Board approved the application of what would be our nation's first religious public school. The approval of the Catholic school was recently overturned by the Oklahoma Supreme Court. In 2023, Texas legislature passed a bill allowing public schools to hire chaplains with safety funds to help address mental health. In 2024, Louisiana lawmakers passed a bill that would require all public schools in the state to display the 10 Commandments in every classroom. In 2022, the Supreme Court ruled that Maine can't exclude religious schools from a program that offers tuition aid for private education. In an effort to provide guidance for public school students, administrators, parents, and board members, the U.S. Department of Education updated its guidance on constitutional protections for prayer and religious expression in public schools in 2023. Under the Elementary and Secondary Education Act of 1965, public schools must comply with these standards, and districts receiving federal funds must certify annually that they do not restrict constitutionally protected prayer. The main points can be seen on this slide. Throughout much of the 20th century, Supreme Court rulings tended to emphasize the separation of church and state, sometimes resulting in decisions sought to remove religious influences entirely rather than accommodate them. However, in the 21st century, Supreme Court decisions have increasingly interpreted the First Amendment in a way that reaffirms both religious exercise and institutional participation. The shift suggests that the courts are moving toward an interpretation more aligned with the historical intent of the First Amendment, allowing robust religious expression while still maintaining that the government does not establish or mandate any specific religious practice.